Hi, I'm Anwiti Singh, and you're listening to Three Things, the Indian Express news show. In this episode, we talk about the delimitation exercise that will start in Assam soon. We also give an update about a Supreme Court judgment which says cinema halls can ban moviegoers from bringing food from outside. But first, we talk about another verdict by the Supreme Court. On Monday, the Apex Court delivered a judgment on demonetization. 6 years ago, on November 8, 2016, Prime Minister Narendra Modi addressed the nation to announce that Rs 500 and Rs 1000 notes will not be legal tender after midnight.
To break the grip of corruption and black money, we have decided that the 500 rupee and 1000 rupee currency notes presently in use will no longer be legal tender from midnight to night.
Following the decision came criticisms, appreciations, and long queues outside banks and ATMs.
कल रात 8 बजे से करीब 1 बजे तक लोग सड़कों पर देखे गए। 500 और 1000 रुपए के नोटों को खपाने के लिए सबसे ज्यादा भीड़ पेट्रोल पंप्स पर देखी गई।
People continue to stand in long queues outside banks and ATMs as they face the woes of the note ban. Even after a month, their worries continue. The initial excitement.
After the decision was announced, around 58 petitions were filed in the Supreme Court challenging the ban. The petitioners argued that it was not a considered decision of the government and should be struck down by the court. Now, 6 years later, the Supreme Court has finally delivered their verdict. In this segment, first, we speak to Indian Express's Apurva Vishwanath, who explains to us how the arguments worked out in the court. And then, Indian Express's Udit Misra will briefly tell us about the impact of demonetization on the Indian economy. So, Purva, can you first tell us about the judgment that came out on Monday?
So, this is a 5-judge constitution bench verdict in which 4 judges essentially upheld the government's 2016 decision to demonetize currency notes. There were about 6 questions that the court had framed for itself on the legal issues regarding the Reserve Bank of India Act and the powers under which the government could have initiated such a process. So on all of those, each of those 6 questions, the majority verdict goes in favor of the government, and virtually all other arguments that were made against the government's decision have sort of been dissected by the court, and it's been in favor of the government here.
Okay, and what was the central question or conundrum for the bench, regarding the petition?
Yes, so the central, question in all of this is about Section 26, subsection 2 of the RBI Act. It is under this provision that the government has power to issue a gazette notification, like it did in 2016, on essentially making sure that any series of banknotes of any denomination shall cease to be legal tender. So this ceasing to be legal tender is what essentially the demonetization process is. The first question was whether, since the provision says any series of any denomination, but the government's decision was basically demonetizing all series of 500 and 1000. So was that permissible? The question was whether you could read any as all. Because if you look at the previous instances where a particular currency has been demonetized, that happened through a legislation. So the question was whether, under an official gazette notification, could you have demonetized all series of a particular currency? So here the majority view says any can be read as all. And they say this is some sort of a purposive interpretation of the provision, which is not pedantic, and it can be interpreted as all series of all denominations. The dissenting view, of course, by Justice Nagaratna disagrees and says that if you read any as all, then the government can essentially demonetize all currency, that exists right now, like from your 1 rupee to 5 rupees to the 2000 rupees. Anything can happen. Such vast powers theoretically cannot be allowed, and that's arbitrary. So Justice Nagaratna there draws a line and says the government will have to only read this as some currencies, all series of some denomination. And then if it wants to demonetize all currency, then it would have to necessarily do it through a legislation. So it would necessarily have to bring in a law to do that, and not through this Section 26(2) of the RBI Act. So this was the first, or the, central question that the court had to answer. So the other issue with Section, 26(2) was also about who initiates this process. Because the provision says on the recommendation of a central board of the Reserve Bank of India. Here, the majority verdict says it's essentially a consultative process. It doesn't matter who started the conversation. And, if the RBI and the government were on the same page and they had talked about it for 6 months, then it's all kosher. But the dissenting verdict again draws a line there and says, from the record that is presented to the court, it appears as if the proposal did not originate with the Central Board of the Reserve Bank of India, but came to them only a day before 8th of November 2016, when the demonetization was announced. So here the dissenting opinion says that since there was no application of mind by the RBI, and how could they, because they only had 24 hours, the criteria, or the Section 26(2) criteria, is violated and cannot be upheld.
Right. And Apurva, apart from the central questions that were raised, can you tell us about other major issues that were raised by the bench?
So what, we also glean from the verdict is that the majority, and even the dissenting opinion, makes it very clear that they're not looking into the merits of the decision. They're not looking at whether the decision achieved its objective. And on economic issues, the court sort of draws its own Lakshman Rekha and says that we are not in a place to examine that. So although they, in several places in the judgment, refer to the hardship that the citizens faced and sort of acknowledge that, they say it's not within the ambit of the court to look into these issues. So whether the objectives that were set out by the government were achieved or not is something that the court says we will not look into. But on the other hand, the majority verdict also sort of legitimizes many of the arguments that the government made about bringing in a notification in such haste. The court actually quotes a lot of earlier legislative history on demonetization and says that even before, on monetary policy, the government has taken such swift decisions which were shrouded in secrecy. And it sort of approves of the haste and secrecy in which the government made these decisions.
So there were a lot of speculations in the past whether the court could, actually strike down the notification issued on November 8, 2016, which made the note ban possible. Was that discussed in the court?
See, even when the hearing was happening, there was this question about what will the court eventually decide. Even if the court, say, holds this entire decision as unconstitutional, what can be done now? Here, since the majority view does not hold the decision unconstitutional, they don't go into this question. But the minority, or the dissenting opinion, since Justice Nagaratna says this is an unconstitutional decision, there she goes into this question of, but what is the remedy? If it's unconstitutional, so what? The government's argument in court has been that this entire judicial review of the demonetization issue is largely an academic exercise, that there is nothing that the court can do now. And the dissenting opinion also sort of nods to that and says, which it's true, like you can't turn the clock back, so to say. But what it does is draw some red lines for institution building, right? That it says that RBI has to apply its mind in such a huge decision. This is not how the process has to be done. Or says, or emphasizing on the supremacy of the parliament, that central government is answerable to the parliament, and why bringing in a law before the parliament is vital, especially on such crucial issues. So these are all learnings for the future. But as such, even the dissenting opinion says there isn't a relief that you can provide to either citizens who suffered from the decision or the government for having made this decision in an unlawful way.
Okay, and Apurva, what do we take away from this verdict?
So in a sense, legally, this legitimizes the centre's 2016 decision, right? And it gives a judicial stamp of approval on everything that happened. But apart from that, especially because it's an economic policy decision, there is nothing much that the court could have done on this issue. The RBI was not, a petitioner in the case. The RBI was supporting the government. They, even in affidavits, the RBI sort of made it clear that they were on the same page with the government. So in this context, it's only that the issue of demonetization in that sense in the courts comes to an end after 6 years that, the court did delay the hearing for a very long time, giving the government an opportunity to frame its arguments and come back to court with answers, because they did not have many of these answers in November 2016 when the case first came before the Supreme Court.
We heard from Apurva about the Supreme Court's verdict on demonetization, which upheld the government's decision. But many have criticized the government's decision and its impact on the Indian economy. Indian Express's Udit Misra says that the Indian economy was growing when the note ban was implemented, and since then, it hasn't recovered yet.
There is enough and more evidence to prove how demonetization triggered a collapse in the Indian economy because it hit the informal sector.
And we remember that in demonetization, one of the main criticism of demonetization was that the move took away 86% of all money from the economy in one fell swoop.
And it was also very interesting to find that the previous increase, the upswing, actually started in the middle of early 2013. So almost a year before Mr. Modi took over. When he took over, there was an upswing happening. And then after a couple of years, the decision to demonetize was taken. And it turned out to be a really bad one because since then, the economy hasn't recovered. With every passing year, it has very seriously lost the momentum. And this we are saying even without the COVID pandemic, because in 2016-17, we were growing it over around 8.3 or something annual rate. And by 2019-20, which is March 2020 ending, that year we grew at just about 4%. So until then, COVID had not hit us. So we had already lost half of our growth by that time, and we were really looking at a very stark scenario. COVID in many ways has just, in some ways, has masked that existing weaknesses in the Indian economy. And we must not forget it. It's very crucial to understand.
And next, we talk about Assam. The Election Commission is going to undertake the delimitation exercise in the state, which is the process of redrawing boundaries of the Lok Sabha and the State Assembly constituencies. The exercise is supposed to provide equal representation to different sections of a population during elections. But this exercise in Assam is facing a lot of criticism right now, especially by the opposition parties, who claim that the ruling Bharatiya Janata Party government in the state is trying to use it to its own advantage. And even before the exercise starts, the opposition has also been critical of the recent decision by the state government to merge 4 districts in Assam. In this segment, Indian Express's Damini Nath joins us to talk about the process of delimitation, the merging of these 4 states, and what the opposition parties are saying. So Damini, delimitation is the process of redrawing boundaries of the Lok Sabha and State Assembly constituency. But could you tell us when and why this exercise is carried out?
So delimitation is supposed to be done after every census. That is what the Constitution says. It is done so that voters in all constituencies have a similar weightage when it comes to their representation in Parliament. We shouldn't have constituencies which are very small, which have, just 1 lakh or 3 lakh voters, and others which are much larger with 30 lakh voters. That is the basic principle. The population is one of the main criteria for delimitation, but it's not the only criteria. There are other features like the geographical factors, communication lines, administrative units. For example, you can't have a constituency where you have a large mountain range or a river or highways dividing 2 parts of the same constituency.
So you mentioned that typically the delimitation exercise is done after each census. Now the last census happened in 2011. So what is the reason that the Assam delimitation exercise is happening now? I mean, after all these years.
So if we go back and if we see how many times we've had delimitation, there have been 4 times that we've had a delimitation commission appointed for the entire country in 1952, 1962, 72 and 2002. Since then, the delimitation has been frozen through constitutional amendments twice, once in 76 and once in 2002.
And what is the reason that this process got frozen?
So the process was frozen because the government thought that those states which are successful in controlling their population growth should not feel that they will lose out in terms of number of seats in parliament.
So let's say, for example, if Andhra Pradesh has successfully carried out their family planning program and their population is going down, and on the other hand, let's say Uttar Pradesh has not been successful in doing so, then the delimitation exercise should not be conducted at the same time, because then Uttar Pradesh would have a greater advantage?
Yes, and this is something that southern states have raised repeatedly. This is a concern that they have because they've been more successful in controlling their population growth compared to some North Indian states.
Okay, and Damini, now that this exercise is going to take place in Assam, a lot of people, especially in the opposition, have raised concerns about it. What are the things that they're saying about it?
So, when the last Delimitation Commission was appointed in 2002, Assam, Arunachal Pradesh, Manipur, Nagaland and Jammu and Kashmir were left out of the ambit of that commission. It was felt that there were many things that were pending, like the NRC at the time, and there were other law and order issues and security concerns for delimitation not being done in these states. The government tried to do the delimitation in these states again in 2020 with the J&K delimitation. However, again, it decided that this wasn't the time. Now, the government has written to the Election Commission and asked it to initiate delimitation, but only for Assam, leaving out these other three northeastern states. So, opposition parties are concerned about the use of the 2001 census figures when 2011 census figures are available and were used for the J&K delimitation.
Okay, so earlier you mentioned that typically the last census is used for conducting delimitation. But in Assam's case, they're using the 2001 census?
Yes, that is as per Article 170 of the Constitution, which was amended to say that the first census after 2000 shall be used.
Okay, so this is the reason that they're being able to, use the 2001 census data for delimitation instead of the 2011 data. And this is what has raised concerns. What is the opposition saying about it?
So, one of the main concerns is that the population in many of the districts has changed from the 2001 to 2011 census. The representation of minorities in certain districts has changed. Opposition leaders are concerned that this would be unfair to certain communities. Another thing is that the issues that were pending or the problems that were being faced in 2008 when it was suspended last time, they're still there. The NRC has not been finalized. There are still the same concerns amongst student groups and concerns about protests that may break out.
Okay, and Damini, what has the state government's, let's say, stand or statement been about this?
The Chief Minister has welcomed this, of course. He has said that 2001 census should be used because that is also what the Constitution says. He thinks that this would be a way to address the issues of the population and would be better than the NRC.
All right. And now in the middle of all this, the other major development that we have recently seen is that even before the exercise can start, the BJP-led Assam government has decided to merge 4 districts with the districts they had been carved out of. What does the administration say about the reason they did this?
So when the Election Commission announced that it would do delimitation for Assam, it wrote to the Assam government and told it not to change any of the administrative units from 1st January onwards. Just on the eve of that, the Assam cabinet had a special meeting in Delhi and decided to merge 4 districts into the districts from which they were created. And one of them was as recently as January. The Chief Minister did not specify a reason, but he said this was because of administrative reasons. And he said this would be temporary and these districts would be carved out again as soon as possible.
And what has been the opposition reaction to this development?
So the opposition has said that this move is basically to polarize voters. They feel that this would give the BJP a chance to carve out constituencies to their advantage, with the minority and majority population being balanced out to as per their wishes.
And Damini, speaking to some of these concerns, could you talk about these districts that are going to be merged?
So there are 4 districts which are being merged into the districts from which they were created. There's Tamulpur, which will be merged with Baksa, Hojai, which will be merged with Nagaon, Vishwanath, which will be merged with Sonitpur, and Bajali, which will be merged with Barpeta. The opposition has seen this move as an attempt to create more Hindu majority seats because 2 of these districts are majority-minority districts. So the Congress feels that this is being done by the BJP to carve out seats as per their own wishes.
And in the end, we give an update for moviegoers. The Supreme Court on Tuesday said cinema halls have the right to bar moviegoers from bringing in food or beverages from outside. A bench of Chief Justice of India, D.Y. Chandrachud, and Justice P.S. Narasimha said the halls must, however, provide free hygienic drinking water to the viewers and allow parents to carry food for infants accompanying them. The bench was hearing a plea challenging the July 2018 Jammu and Kashmir High Court order lifting the restriction on moviegoers to carry their own food to cinema halls. The bench said, and I quote, "The property of the cinema hall is the private property of the owner of the hall. The owner is entitled to set terms and conditions so long as such terms and conditions are not contrary to public interest, safety, and welfare. The owner is entitled to set terms for sale of food and beverages. Moviegoers have the choice to not purchase the same." Unquote. Setting aside the order, the Supreme Court said, and I quote, "The High Court transgressed the limits on the exercise of its jurisdiction," pointing out that there were no statutory rules to order so. The top court added that the imposition of such directions would affect the legitimate rights of theatre owners. The counsel appearing for the respondent argued that the movie ticket was a contract between the individual and the state, and as long as no prohibition is printed on it, theatres cannot bar outside food. However, Justice Narasimha remarked that the basic premise is that cinema has a right to reserve admission. The cinema owners have a right to sell their own food and beverages. Appearing for the appellants, senior advocate K.V. Vishwanathan too contended that cinema halls were private properties and could reserve the right of admission. He said, the Jammu and Kashmir Cinema Regulations Rules 1975 did not have any provision allowing a moviegoer to bring in outside food and that no cinema was compelling anyone to buy food. Agreeing that a cinema hall is a private property, C.J.I. Chandrachud said, "It is not a gym that visitors need healthy food, but a place of entertainment." He added, "What goes in is for the owner of the property to decide. So saying that arms are not allowed or no discrimination on the basis of caste or gender can be there is fine. But how can a high court say that they can bring any food inside cinema halls?" He asked who would pay for cleaning if someone starts getting jalebis and wipes their hands on the seats. He added that people may also bring tandoori chicken and leave bones, which can again lead to complaints. The court said that, quote, "For water, we make a concession that free water be provided at movie theatres. But at the same time, you can't say that suppose they sell Nimbu Pani for ₹20, you can't say I will go and buy my Nimbu from outside and squeeze it in a flask and take it inside the theatre." Unquote. You are listening to The Three Things by the Indian Express. Today's show was hosted by me, Anwiti Singh, and written and produced by Utsa Sarmin with the help of Shashank, Bhargava, and me. It was edited and mixed by Suresh Pawar. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone who you think will like it. Share it with a friend or someone in your family. It's the best way for people to get to know about us. You can also tweet us at Express Podcasts or write to us at podcast@indianexpress.com.